I'm Tom Collins, Executive Director of Clean Elections, Arizona's nonpartisan voter education agency. And we're here today as part of our ongoing series of interviews with subject matter experts about issues facing Arizonans on the ballot this year. Today's topic we're talking about is abortion. And to talk about that and its legal landscape, we're joined by Professor Barbara Atwood, who is the Mary Ann Ritchie Professor of Law Emerita at the James E. Rogers College of Law at the University of Arizona in Tucson. And Professor Atwood has more than 3 decades of experience in family law, teaching, and research. And she's here today to help us shed light on what can be a very controversial topic for voters. So thank you very much, Professor Atwood, for being here.
Thanks for having me, Tom.
One of the things that I think that we're all trying to sort of ground ourselves in is, where we are as far as the legal landscape here in Arizona. Over the course of the past, 24 months, we've seen a couple of different shifts. So, how has the legal landscape here in Arizona changed since the Dobbs decision overruling Roe versus Wade?
It's been chaotic. In fact, you might say that Arizona's been more chaotic than almost any other state. And part of that is because Arizona, up until this past summer, had on the books a territorial ban against abortion that criminalized the performance of an abortion except to save the life of the pregnant woman. But let me go back to the spring of 2022. The Arizona legislature enacted what we now call the 15-week law. They copied what was happening in the state of Mississippi. Mississippi also had a 15-week law. And at that point in time, when Roe v. Wade was still good law, people believed that a 15-week law, a law that outlawed abortion after 15 weeks of gestation, would be unconstitutional under Roe v. Wade. The Mississippi legislature decided to enact that law to push the Supreme Court. And they felt that there was a new composition in the Supreme Court and that was the chances of overruling Roe v. Wade were pretty good. The Arizona legislature, as I said, enacted this 15-week law and, in a sense, held its breath to see what was going to happen with the Dobbs case as it wound its way up through the state court and then up to the U.S. Supreme Court. As we know, Dobbs ended up overturning Roe v. Wade and abandoned that precedent that had been law for 50 years. When that happened, and in so doing, it upheld the 15-week law in Mississippi. It found that there was a legitimate rational basis for it and didn't impose any kind of special constitutional scrutiny. That meant that Arizona's law, likewise, was going to be upheld as constitutional. At that point in time, Attorney General Mark Brnovich was in office, and he declared on Twitter, actually, that this old territorial ban was now in effect, because he said, and he was right in his analysis. He said, "Gee, the reason that was struck down back in 1973 under Roe v. Wade was because of Roe v. Wade, and Roe v. Wade is now gone. Therefore, that law should spring back into life." When I say he was right, what I mean is that he was right in saying that it was struck down only because of Roe v. Wade. He was wrong in the sense that it might, in and of itself, spring back into life, because Arizona, unlike about a dozen other states, did not have a trigger law, a law on the books that said, if Roe v. Wade is struck down, our old bans will come into being. What Attorney General Brnovich did was to file a lawsuit, which he had to do in order to sort of accomplish his goals, down here in Tucson, because this was the forum where the old litigation challenging this territorial ban had been commenced back in 1973. And so he went to that court, to the Superior Court here in Tucson, and said, you've got to lift the injunction against this old ban because Roe v. Wade is now a dead letter. And that case wound its way up through the state court system with the Superior Court judge initially agreeing with Attorney General Brnovich. It went to the Arizona Court of Appeals. That court imposed a very different kind of analysis and said, wait a minute, the 15-week law is good law. We're going to give a fairly limited effect to this old law and essentially leaving the 15-week law in place. That then went up to the Arizona Supreme Court. In the meantime, Arizona's executive branch changed parties. We now had a Democratic governor and a Democratic attorney general, and they did not want to make an argument that the old law, this territorial ban, was effective. And so they said, we're not going to go into court and make that argument. But there were interveners that decided to make that fight. A doctor who purported to represent all unborn children in the state of Arizona and a county attorney joined as well to defend Mark Brnovich's original position that the territorial ban, which again, it absolutely prohibits abortion from conception forward except to save the life of the mother. And that case then was finally resolved by the Arizona Supreme Court back in April, got a lot of press. It was a divided court. And it held that, in fact, Attorney General Brnovich's original analysis was right, that there was no basis for not basically putting the old ban into full effect, given that the Arizona legislature had kept it on the books from 1864 through 2024, changed the numbering, but kept the language of that law on the books, even though for 50 years it was unconstitutional. And so they read the legislature as really intending that it be reinstated once, if and when Roe v. Wade were to be overturned. That produced an outcry in the state. You know, we're only talking a few months ago. It made national news. And as a result, there was a lot of pressure on the Arizona legislature to finally repeal that law, which they finally did this past summer. It was all Democrats and a handful of Republicans in either house voting to repeal the old ban. The effect of that was to leave this 15-week law in place. There have been some issues about timing because that legislative repeal was not going to, according to normal legislative rules, it doesn't go into effect until 90 days after the legislature adjourned. They adjourned in June 15, and that means that the repeal will be effective actually next week. We're here on the 10th of September. Around the 15th of September is when that repeal will be effective. And that means that there is no chance that the old law is going to be in effect. There have been some complicated timing issues and delays of the Arizona Supreme Court's opinion that makes that happen. So at this point in Arizona, we have a lot of laws that regulate abortion, that require informed consent, and under the sort of topic of informed consent, impose quite a few requirements on people seeking abortions. But the 15-week law provides that abortion up to 15 weeks of gestation is available without restriction as to, let me just say this, elective abortion is available up to 15 weeks of gestation. After 15 weeks, under this law that, again, was enacted in the spring of 2022, before the Dobbs decision, after 15 weeks, abortion is available for a medical emergency. And that is defined in Arizona as meaning when the woman's life is at risk or there will be permanent impairment of a major bodily function. So very serious health issues, physical health issues, or death. There's no rape or incest exception in that law. So that's where we stand right now. But there's going to be probably some changes. We don't know.
Right. Well, so that kind of, I mean, I think that that last point highlights, I mean, one of the things that, we're, in that part of our effort to try to focus on. So, we have, on the ballot, we have an initiative that would, codify a right to abortion, and that's different from the 15-week ban. And then we also have a or ban after 15 weeks. And then we also have a federal election where we have the presidency, the U.S. Senate, and the U.S. House, all, the control of each one of those offices and bodies runs right through Arizona, right? We're a swing state for the presidency, the Senate, and the Congress. So one of the things that we are trying to I think as voters work through is, what is the state role here in regulation? What is the federal role here in regulation, and how those two interact? Because from your answer, from talking about this so far, we see an interaction between federal courts, state legislature, the governor, and the attorney general. So how will that how can people start to get their arms around that as they're looking at a ballot that both has the substantive question and decides the offices that bear on it?
That's a really interesting question. What you see right now across the U.S. Are 10 states have state constitutional amendments on the ballot, Arizona included. And that's a response to the Dobbs case, which eliminated the federal constitutional protection for abortion decision making. So one answer to your question is that state constitutional law has become, since Dobbs, center stage in importance in for people who are reproductive justice advocates. They are central stage for protecting reproductive rights. At the same time, federal there still is a preemptive effect for federal statutes. For example, a federal statutory law that is inconsistent or conflicts with state constitutional law, the federal statute would prevail. It preempts state law. And there are some arguments by Democrats, I think, in Congress that we're going to, if we attain a majority in both houses, we're going to try to push through some statutory provisions protecting access to abortion. My sense is that that's unlikely to happen, because I think no matter, even if the Democrats were to be successful, I doubt that they would get a majority, a supermajority necessary to overcome, a filibuster. So that's going to be, I think, we still hear people talking about what they're going to do, both on the Republican side and on the Democratic side, with respect to abortion. But frankly, I don't see outright legislation on that front as being something that's going to occur just because we are going to have closely divided Senate and a closely divided House, no matter who's going to be in the majority. There's also another piece of this picture, this changing landscape, is the regulation of the abortion medication. And we know now that most abortions in the United States, almost 2/3, are accomplished through medication. This two drugs, mifepristone and misoprostol. That means that the regulation of those drugs all of a sudden has become extremely important. And viewers may have been aware that the US Supreme Court had a challenge brought by a group of physicians identifying as right to life doctors in Texas, challenging the FDA's approval of these drugs and their use for terminating pregnancy. The Supreme Court this spring essentially dismissed that case for lack of standing, not on the merits, but simply saying none of the plaintiffs really had a stake in the outcome sufficient for them to move forward looking at the case as a case or controversy. But in the opinion itself, Justice Kavanaugh, who wrote the majority, reminded people that there are ways to have your views felt by the federal government. You can lobby the FDA, for example, and try to get them to maybe be more restrictive about these drugs. And I think that those efforts will continue. There may also be litigation with different plaintiffs. Some people think that states themselves might be able to bring such a lawsuit. My point is that there's a federal overlay of drug regulation that can have a tremendous impact on abortion just because of the importance now of these abortion medication drugs and the sort of ease of access to them.
I think that's a really interesting point. So, over the course of this conversation now, we started with a Superior Court action in Pima County. We have talked about a state Supreme Court action. We've talked about several Arizona state legislative actions, a number of U.S. Supreme Court decisions, a whole administrative regulatory regime, and then moving even into the regulation of drugs as associated with this. So, I mean, it's sort of one of the questions that brings to mind is, as in this post-Dobbs period, policymakers at the legislative level or congressional level are working through this stuff. There are going to be a number of different areas of healthcare policy and family law related policies that are going to touch on this. For example, if you follow organ donation, some of the developments along the lines there in terms of how that interacts with some of the regulations around different forms of research has been something that has been an issue that's sort of in the background. I mean, so I guess what I'm trying to say is, how we're trying to sort of sum up how complex and how many ways in which these different lawsuits and regulatory actions touch on issues even beyond what people might sort of think of as just as abortion itself. I think it seems like people maybe underestimate how much these different decisions do touch on what might be categorized as other issues.
No, I think that's right. There's another federal law that requires that hospitals that receive any kind of federal funding provide emergency care to patients regardless of their insurance. This was enacted back in the Reagan era, but that's become also a battleground in the abortion topic because some states have restrictive provisions that would ban abortion even if the need for that abortion is an emergency need to protect the woman's health. This might be a state such as Idaho that bans abortion unless necessary to prevent death. And doctors in the state of Idaho have had to send patients out of state for emergency care that where death itself was not the risk, but severe health impacts were predicted unless the woman received an abortion. And so that's been a battleground where abortion rights advocates say, well, you've got to pay attention to this law, and this federal law requires the states to provide emergency care, including abortion, when necessary to protect life or health. People on the other side very strongly argue that state policy doesn't have to give way to that kind of federal law. And that's a battleground that involves, I think, serious constitutional questions about when there is preemptive effect of a federal statute. It's ironic that the U.S. Supreme Court, back in 2022 in June, when it decided the Dobbs case, the tone of the majority opinion is, in a sense, we're going to get out of this very messy abortion business because it's complicated and it hasn't gone well for us, and we're done with it. But they have had 2 abortion cases on their docket this term, and it will continue because there are some very unresolved, serious questions. Another one that I'll just mention to you is that about 20 states now have what are referred to as shield laws. And these are laws that prevent the state from cooperating with other states in prosecuting people for violation of those other states' abortion laws. And so it comes up in this realm of if a state with very restrictive abortion laws has a person in that state who wants to seek an abortion and travels to another state to obtain an abortion, the state with the restrictive law, many of them have passed laws saying, if you travel out of state to seek an abortion, we're going to treat that as an offense in our state, as a criminal offense, or we're going to treat the people who perform that abortion on you as violating our criminal law. And you have states on the other side saying, we're going to shield anybody who comes into our state for an abortion, and we're not going to cooperate, and we're not going to extradite people, etc. These interstate clashes are completely unresolved. They are kind of, those will ultimately, I think, get to the U.S. Supreme Court.
Yeah.
A lot of smart constitutional law scholars have thought about this, and there's quite a bit of disagreement, frankly, about where the Constitution would come down on these clashes. So, but at the state level, in the state of Arizona, this constitutional amendment that's proposed would change the law drastically, but it will take litigation to determine exactly which of our existing laws would survive a challenge under that proposed constitutional amendment. So I don't know if you are wanting to talk about that, Tom, but
sure. I think that would be a good place to for our last question. So continue, please.
Okay. So the what's called the Arizonans' Access to Abortion, this proposed amendment that's on the ballot, will it declares that there is a fundamental right to abortion, to reproductive justice. It up to the point of fetal viability. It provides for elective abortion. After fetal viability, abortion must be provided if necessary to prevent the death of the pregnant person or serious mental or physical health risks. And there's some language in the proposed ballot proposition that defines the reasons that states, the room in which states can, let me just start over.
Sure.
There's language in the ballot proposition stating that the state can only regulate the pre-viability space of abortion for a compelling state interest. And it defines compelling state interest as regulations needed to protect the health of the pregnant person. That is, I think, going to be where there's going to be litigation
Sure.
because, as I mentioned at the outset, Arizona has a number of regulations right now, restrictions on abortion or requirements that fall within the broad category of informed consent, a mandatory waiting period and mandatory sonograms, people seeking abortion being told the fetal stage of fetal development, that sort of thing. And I think I can predict that under this constitutional amendment, if it passes, there will be an immediate challenge to a lot of the existing laws, including the 15-week law,
Sure.
uh, by providers. And there will be people defending those laws as necessary to protect the sort of the goal of every woman having informed consent.
Yeah.
It's going to be a little complicated because I think the executive branch, again, the attorney general and the governor, will be willing to agree that our existing laws should fall under this constitutional amendment.
Right.
But I imagine a court will allow interveners to come in
Sure.
and defend those laws. So it's it's going to be a very interesting set of circumstances out there. I think that the 15-week law for some people seems like a reasonable law. We do know that empirically the vast majority of abortions are obtained before that 15-week demarcation. On the other hand, the 15-week law is unforgiving for abortions post 15 weeks. Again, there's no rape or incest exception,
Yeah.
and the idea of emergency and a medical emergency is defined, I think, quite strictly. So it is, unfortunately, I think, a law that has some impacts on people with late term anomalies appearing in their pregnancy. There are, in other words, the 15-week law, people have tried to point out the ways in which it can have an impact that's quite severe on people whose pregnancies are very much desired, but where the problems don't appear until after 15 weeks. So we shall see what the voters do in
Right.
Arizona. There's going to be a lot of, I think, heated opposition and also very strong uh, ads by folks who are the proponents.
Absolutely. So, as we move ahead, with this, thank you, Professor Atwood, for all of this, for going over this, I think, complicated issue. But I think if folks take the time to listen to this interview and understand the factual and legal backdrop that voters are operating under, I think that will help folks to better understand the situation, where we are now, and in fact, what's on their ballot. So, voters, if you are interested in finding out more about candidates and where they stand and the ballot measures, as well as to see debates on both the ballot measures and between candidates, you can check out our website at azcleanelections.gov. You can also there watch all of our wonderful subject matter expert videos to uh, get prepared to vote informed. Remember that voter registration deadline is October 7th. Election day is November 5th. And thank you very much for joining us.